You may proceed.
Thank you. Your Honors, before you is a workers' compensation case, a procedure that I'm sure you're all familiar with, but is totally different than the civil litigation that the courts of this Commonwealth are usually involved with. There are simplified procedures. Claimants are supposed to come into the comp board, produce their documentation, their issues, their witnesses, and a substance of what they're going to say. We did that at what's called a Section 10A hearing. Okay? Attached to the employer supplemental appendix is my memorandum that I filed. In response, the employer filed nothing at that hearing, and the insurer filed a witness list and an exhibit list, but no substance of the facts that were going to be controverted.
Is your claim essentially, and please tell me if I'm reading it wrong, but is your claim essentially really that the administrative judge's finding that the employee went out the window was arbitrary and capricious and not supported by the evidence? Is that
That's one part
one
of the claim,
part of
yes.
your claim, and the other part is that
Yes. And
about
specifically,
Section 28 being incorporated into Section 7. That's the other part.
yes, specifically with the window, there was no evidence whether the employee could fit through the window. And if you look at Mr. Clement's testimony, the driver, the judge says he made a correction to or clarified his testimony. Yet, did he really clarify it when you read that information? He still says in his testimony, the employee didn't go out the window. I have no reason to believe that.
Okay, what in Section 7 is there that puts Section 28 into it? What are the words in Section 7 that...
7A?
7A would be the presumption, Your Honor.
7A, yes.
Section 7A was interpreted by Thayer's case to mean that any claim within this chapter will be, I think, in simple terms, will be presumed to have been proven, unless the opponent comes in.
Well, that's certainly not what Thayer's case talks about. Thayer's case is whether or not Section 41, I think, which is the requirement that all proceedings be filed within a certain time period. And Thayer's case basically says that all proceedings includes all proceedings, right? That includes Section 28 proceedings.
Am I, perhaps I'm confusing the case law, Your Honor. I believe it's the case that says Section 7A has the language for all claims that come within this chapter.
Well, and the Anderson case interprets Section 7A. Yeah,
Anderson's case, forgive me. I reviewed the Thayer case. It's the Anderson case, and I believe the Anderson case is the one that answers Your Honor's issue.
But that's, I think it's just reading much more than is in there. I mean, Section 28, just because it says that a claim, if someone is, I'm sorry, Section 27, not Section 28. And it's prima facie evidence that the employee was performing his regular duties if he's killed on the job. Okay.
You're talking about 7A, aren't you?
Yeah, 7A. But then how do you get in there the section, the double damages for, and the serious and willful misconduct in Section 28? I just don't see how you read that into Section 7A.
Well, Section 28, the double compensation, is a claim that comes within Chapter 152. And so the Thayer case, I believe, said...
Anderson.
Yes, excuse me. Anderson case says for all claims in this chapter. And I believe the interpretation by the court was if the legislature wanted to exclude any claim within this chapter, they wouldn't have put that language in.
Well, this doesn't make sense.
Did you put in any evidence that the door latch was defective or the door was defective?
Yes.
And your contention is that was not rebutted. that this business about he went through the window is just unsupported completely.
Yes, correct. On page 38 of our appendix there's a violation notice by the state police. And the 6th violation down says 3 screws are missing from the door latch. There are only 3 screws holding it to the door. And I have to tell Your Honors that
Do we know that to be a fact also?
it was in the violation notice.
Well, I know, but 3 screws, do we know? Is there evidence that there were only 3?
Yes, the record
That
shows,
there are only 3 screws holding the latch to the door?
yes.
Okay.
The judge took Trooper McCarthy's testimony to mean that 1 screw was in the door. And if you read Trooper McCarthy's testimony, there's something a bit confusing and there's an objection. But then right after that, we offer a photograph which shows the door with 3 screws missing.
But there's evidence before the accident, I guess the night before, that there was 1 screw missing, 1 screw loose, and 1 screw tight, right?
That's from the driver.
Right? So, but isn't it possible, when you say the violations show 3 screws missing, that's after the accident, correct?
Immediately after the accident, as the truck was lifted
But
off the ground.
or the trauma is maybe not the right word, but the impact of the truck on the ground, couldn't that have knocked them out?
The expert we put forth said the happening of the accident would not have caused the screws to come out. What we do know from unrefuted testimony of the employer and the driver is there was a problem with vibration, that screws would vibrate out of these latches. They had problems months before. They had problems the night before. And I offered a regulation, Federal Motor Carrier Safety Regulation 393.203, to show that broken door parts shall not be broken or missing.
If we accept what you're saying about Anderson, then isn't the end result of your argument that to say that employers have caused every workplace death since Section 7A was passed because of their illegal actions? Isn't that where you end up?
That's where you start.
Well,
But the cases
isn't that somewhat illogical?
But that's rebuttable.
That's rebuttable, and that's why I say that's where you start, and the reason being, the employee's not here to help us. It's the statutory aid, the evidentiary aid that the employer is given in this beneficent statute. The easy cases will dispose of that
So what
quickly.
you want out of this case is first that it's prima facie evidence that you get double damages, and then a remand to have it done over again, because you say this decision is arbitrary.
I do say that. The decision is arbitrary. I think the proper procedure would be to remand it to the DIA,
Right.
Well, that's
let them make their findings in view of the guidance of this court, if you should so choose to say Section 7A applies, the presumption applies.
Not to have it retried?
I don't know. I hope it doesn't have to be retried, Judge. It is over 9 years old almost. I think
certainly-
at first start.
Certainly, the employer has the right, I mean, assume for the minute that's what happens, the employer has the right to rebut that presumption.
Correct.
Does, and the record has been established. We put this presumption off in our conference materials. The employer and the insurer should have responded to at that time. They elected to proceed thinking, well, it doesn't apply.
Well,
or it does.
if we don't agree with you about the judge's finding that the employee went out the window, aren't there enough facts here to rebut the presumption? I mean, didn't the hearing officer effectively do that, even though he put the cart before the horse?
I'd say no, because the entire case was evaluated without the presumption. I think there's a difference between, and that's like the harmless error defense.
Except that didn't the hearing officer find that he went out the window? If that fact is supported by the record, doesn't that rebut the presumption of the door latch being defective?
The cause, or the door latch being the cause.
I think she'd have to explain why that evidence, weighing the evidence, why it is more important to accept the allegations that he went out the window compared to all this other evidence that has a prima facie effect.
But there was a whole bunch of, I mean, there were a lot of witnesses. There were all, and obviously there were, the judge made credibility assessments, believed some evidence, not others, found some more persuasive than others, made findings on the basis of that evidence that the latch mechanism was not defective, that it was in proper working order at the time of the accident. and that the door did not open when the floor tipped over, the car tipped over, and then he was ejected through the window. You're saying there's no evidence of that in the record?
Not in view,
Yeah,
the
there's
only evidence,
conflicting evidence, but there's certainly that evidence is in the
the
record.
only evidence there is Mr. Clement. That's the only evidence.
Well, the evidence is that if the door had opened, it would have been damaged in a way differently from which it was damaged.
And I don't,
And that, go ahead.
if you look at
And that the window was open.
if you look at the appendix at page 48, you'll see curling at the lower edge of the door. And if you look at the insurer's expert, he went into this case saying the door opened, but that the employer reached down and pulled the latch to allow his escape from the truck. That was the insurer's expert. That's why I say in pre-hearing procedures, we produced our information. We got an expert disclosure from the insurer saying the door opened, but the employee was responsible for it. Nothing, not a shred of information or evidence that the door didn't open until Mr. Clement testified at the hearing.
And you called Mr. Clement. He was the driver of the vehicle.
He was the driver of the vehicle. We
Another
called him.
employee.
We had listed him, and we didn't have a chance to question him in advance. There were no procedures to establish evidence in advance in a
But
comp
he
case.
wasn't the witness of the other side either. He had his own lawyer and everything.
Mr. Clement, no, I don't believe he had a lawyer. The only lawyers are sitting to my
No,
my
but
right.
he wasn't their witness either.
They had spoken to him. I believe the record shows they had spoken to him. They had access to him, and you have to accept the fact that he went out the window. You have to believe that he clarified his testimony. He actually said that. When there is sufficient information in the transcript to show he didn't clarify anything, he just didn't see the door open. That's the basis of what he said.
How big was this man?
Mr. Morse was, I think the autopsy report shows him about 6 feet and
What weight?
a big, something tells me about over 200 pounds, Judge, but I
And there
am
was
not
no
sure.
evidence, was there, in the record of how far the window was open?
No evidence at
Except
all.
that it was March, and one would think that the window wasn't open all that wide, but who knows?
No evidence at all, Judge. And,
It seems kind
I-
of strange for a big guy like that to go through a window.
it would seem that, Judge. And the other point which I can just ask you to consider is there was specific reference to seatbelts. The judge found the proximate cause of the employee's death was he wasn't wearing a seatbelt.
No, didn't she
no,
find
she
that the
just has
proximate cause was Simmons going the wrong way or whatever? Simmons hit the
That
truck.
set the forces in motion.
But that was the proximate cause, she said, I thought.
That was, and was that reasonable to say that that caused Mr. Morse's death? Whereas if there was a proper working latch, Mr. Morse probably
Well,
would not have died.
If he was sitting somewhere else in the truck, too, he wouldn't have caused his death. But the proximate cause, she found, was the collision of the two vehicles.
She did mention a seatbelt in a footnote as well. And she
Yes,
said
in footnote.
the fact that he was't wearing a seatbelt proximately caused his death.
Was there
In that
any
footnote, she
evidence?
says that?
Well,
In
what's
a
the
footnote.
significance of that? I mean, the company can't force him to wear a seatbelt.
That's right. There were no work rules, and the state of Rhode Island law, and I believe Mass law at the time, and I supplied these to the judge, was there was no requirement to wear a seatbelt. So how can you say it's the employee that caused his death? There was also no evidence that seatbelts were working. The employer, the employer or the insurer put in the conference papers that there were working seatbelts. They'd prove it. They didn't prove that. I don't know how the judge could have found that. Without
Is
more,
there-
Your Honor?
I see the seatbelts mentioned in footnote 3, but is there somewhere else?
If I can look.
Because I
Your
sure
Honor.
don't see a proximate cause finding there.
Well, we can look.
Yeah, it is referenced, Your Honor. I will represent that.
Okay.
And, thank you.
Thank you, Mr. Sullivan. Mr. Hensley, you have 10 minutes. Good morning.
If it pleases the court, my name is Dan Hendry. I represent the employer in this matter. Excuse me. It had been my intention to try to address the questions that the court was directing toward the potential amicus writers, but I'd like to respond a little bit to what my brother just said. I think it's fair to state that Judge Brendamule, in deciding that this unfortunate employee went out the window, did so in part because she found basically total evidence that the door did not open. It was a fact that this individual was ejected, no question about that, to his death, no question. But she found that the door did not open based upon every single precipient witness, based upon the history that the precipient witnesses indicated about the suspect latch, and based upon the...
So the inference then is the only way he could have gotten out is through the window.
That's the inference I think she had to draw. I think from her decision, she also found facts that supported that, and it's thus more than an inference, Your Honor.
Oh, really? What were the facts?
That evidence would be that the driver, Clement, said the window was open, that the driver, Clement, indicated that the middle passenger, picture three moving guys on a bench seat in a van, tipping to the right. Unfortunately, the deceased was the far passenger side, Clement's driving, individual in the middle. Clement testified on direct by the widow that the middle passenger, he saw him falling down up against the door with his arm scraping the road. So he's up against a door, at least closed in part, one has to determine, and his arm is scraping a road.
This is when the truck now is tipped over.
It's over, scraping along the road. I think the court would have been absolutely able to...
Well, it's over on the door, right?
Yes, indeed, Your Honor.
So of course it's going to be closed then.
Of course it is. And it either already was closed and never had opened, or was closed, had opened
And
and
by
closed.
then, the deceased is outside.
Yeah.
Deceased is outside. The point, however, is regarding whether or not the window is open. The middle passenger has his arm rubbing against the tarmac.
Out the
Court.
window.
Either that or through the actual door, so clearly out the window,
Well,
Judge.
you say the door's closed, so not through the
That's
door.
what the evidence was. So in addition to the fact she found the door never opened, and I believe the transcript is chock full of support for that.
Is it the case that immediately after the accident, that the investigation showed there were no screws in the door?
Well, it's somewhat convoluted, frankly, Your Honor. The Officer McCarthy, rather, the only police officer who was called, testified, my brother thinks somewhat unclearly, it was so found by the judge to have testified that there was one screw. There is a citation by Mr. Ordine, D. Ordine, rather, a Rhode Island inspector, who said after the fact there was no screws. And there's a picture that looked like there were no screws after the fact. In fact, that was the basis for the employee's expert's opinion that, gee, there are no screws after it, there must have been no screws before it. The judge found otherwise, based upon not only what the employee's expert opined regarding how these latches actually worked, but also based on what people actually said. It was reported that the last time this door was closed before the accident, they're finishing up a job, getting ready to come back to Fall River, a witness, Kenny Robitaille, actually closed the door. He closed it exactly in the same way he closed the exemplar at trial. He testified that it closed securely. The judge credited that.
Did he testify, because he was in the truck right behind there, right?
Yes, he was.
Did anybody testify having observed the door open, or?
There was no testimony either way.
Did the administrative judge draw any, excuse me, inference from the fact that the son of the deceased did not testify?
The record is incomplete before you, Your Honor.
Record is what, incomplete?
Incomplete. I had requested that. I represent to the court. The judge did not address that issue.
We don't know much about the size and weight of this guy, do we?
I think, in fact, we may know less than my brother believes we know. There was the autopsy. It's not before this court, if I recollect. I don't think the court really had...
We do know how big the window was. We got pictures or something.
We have pictures, and the widow provided this exemplar, an actual door.
Yeah.
That
So,
the
I
judge
mean, this is
viewed.
a big truck?
Yes, sir. It's a moving van.
Yeah. So it's not a, little itty-bitty car window type thing.
Not the one I saw. And in fact...
Do we know the temperature that day? Is that in the record?
I don't believe that that would be in the record. There was... navigating his way through.
There's warm March days and cold March days.
I know there are, Judge. I don't think the record satisfactorily answers that question.
Okay.
The record does satisfactorily answer the question whether the window was open. There seems to be no
Open
doubt about that.
entirely, apparently.
Well, the
Doesn't
entire
answer that either.
The record is incomplete about that. The case was brought on the assumption that the door latch didn't work, that the door actually opened and was held by a bungee cord. It began to develop that the evidence didn't support that.
No bungee cord was ever found, was it?
Well, this is a moving van, Your Honor. There was a bungee cord found and taken by the state police and eventually given back to my client a year or so later. There was no evidence of any kind suggesting that the bungee cord was used by anybody to do anything other than.
Mr. Hensley, could I just ask you a question, which goes to the presumption question? Did the hearing officer have in front of him, her, the Anderson case? I mean, her interpretation of 7A is it applies only towards 7A, to that which 7A refers to, namely that there's a presumption that he's...
and causation, correct.
Yeah,
Did she have the issue in front of her or the Anderson case?
the Anderson.
Both sides spoke with her about this, and both sides briefed this before she rendered her decision, Your Honor. What didn't happen was in the trying of the matter, no one said, oh, by the way, Judge, before we go forward any further, we have 7A here. I want to make sure that there's an established prima facie case here. And yes ruling or no ruling. That did not happen. We just proceeded.
Well, what she says is it's very limited in scope.
That was her opinion.
Yeah.
Evidently affirmed by the reviewing board as well. So the case was tried in a more routine manner and then argued as to...
Do you read the Anderson case as having the expansiveness that your brother says it does?
I do not, Your Honor.
And why?
Because that speaks only to causation, if memory serves. And it doesn't speak to Section 28. And my brother wants this court and...
No, but I mean, it's, you know,
I agree
7A.
that it expands, Your Honor, what the plain meaning of that statute is, which engenders the question this court had for the amicus briefs, it seems to me. The answer to that is a matter of policy, I suggest. It is one to be addressed by the legislature more properly than by the judiciary.
You could say that about the Anderson case, too.
I think one could say that. What we have here, however, is Section 28, while I understand is not necessarily a punitive statute. It is sure different than a wage replacement statute. It is punishment in a different name of the employer for misconduct. It does not replace a single dollar of wage, and thus is, of all of the aspects of Chapter 152,
To transport 7A into 28 and all the other sections of the statute would be a pretty major decision, right?
Judge Graney, I couldn't agree more. And when that decision is made, one then has to question what sort of notice has to be given to the employer and the insurer as to what exactly it is going on. What is it they have to rebut and for failure to do so?
I mean, at a trial at that point, you would have to go forward with the evidence because the employee could just rest on the prima facie evidence, right?
Absolutely.
It's more than a presumption. It's prima facie evidence, right? Or have I read it wrong?
It is absolutely only prima facie evidence. I don't want to fall
Only,
into the...
isn't that, don't we have cases, at least in the master's area, other areas, that say that's enough
it
to
is
carry
absolutely
the
prima
day in
facie.
the absence of other proof?
It is to be rebutted by the employer and the
And it
insurer.
doesn't just disappear, it remains evidence. And if the
It's a
fact
very
finder
large
doesn't
problem.
like what you put in, they could just rest the decision in the other side's favor on the prima facie evidence.
If 7A brings 28 into the statute, absolutely.
Well, that comes
What do
along
we
now.
do with the other decisions of the board?
Well, that's an interesting problem, Your Honor.
I mean, isn't that, I mean, this is just not out of whole cloth. I mean, two other decisions of the board have said that Thayer's is the underlying case to support the conclusion that 7A does apply. to claims brought under section? No.
There are only one case.
I think we're talking about Pettit, I
Peter.
assume.
The,
The Pettit
Pettit and
case is
the
really
Pettit
on all
case.
fours with this,
And-
unfortunately.
Well, they could simply be wrong.
And Zavalia?
Well,
that's not the same case, so that's not,
I think Pettit is the case that addresses the issue before this court.
it does.
And,
And indeed, in that case, as I read it, the parties actually stipulated to the application of 7A to the,
and then there was some question as to the extent to which the trial judge made the appropriate findings, I think.
right, and the dissent said, I indicate no indication as to whether this stipulation was legally justified.
I agree, Your Honor. The problem is, we also have a reviewing board decision, a summary one at that, in this very case, that at least implicitly finds exactly otherwise. 7A was clearly briefed, clearly argued, clearly addressed by the trial judge, and the reviewing board agreed with her. And I'll give my brother the remaining time. Thank you.
Thank you, Mr. Hensley. Mr. Gaynor?
Case. I know I only have 5 minutes, or 4 minutes and 55 seconds now, so I'd like to just use my time to address some of the issues that the court had raised in questioning to my brothers. The first one would be with regard to the screw. Just so that Your Honors are clear as to what the record says in this case, Ron Clement, the driver, had worked on the passenger side door the night before. There was one screw in there. There was one screw missing, and there was one screw loose. He tightened and snugged the loose screw, and it was tight when he left. Ken Robitaille...
So his testimony could be taken to mean there were 2 secure screws.
Correct.
Okay.
Ken Robitaille, who was the driver of the vehicle that was behind the subject vehicle in this case, had driven the subject vehicle earlier that day before he switched with Clement later on. And he said that the door could close and it could latch, albeit with some difficulty. It did close and it latched. And
So
Ken
in your opinion, there's plainly enough evidence to support a finding that the door latch wasn't defective.
Well, there's more to it than that, but that is one prong of my thought as to why it wasn't defective. The second reason is because it was Ken Robitaille himself who shut the door that Mr. Moss was sitting next to on Mr. Moss's last fateful ride to the accident. And he said it closed and it latched. And when, as Attorney Hendry said, he closed the exemplar door on the morning of the first or second day of hearing. And when asked about it later on direct, how did it feel when you closed the door that Mr. Moss was riding in, he said exactly the same. Third, with regard to that screw, or the screws on the door, Professor Richmond, who was the employee's own attorney, came in and testified that one screw, 2 screws.
Expert?
He was, yes, I'm sorry, the employee's expert testified that 1 screw, 2 screws, 3 screws, whatever. Once that door was closed and latched, it didn't matter if there were no screws in there at that point, because it's latched and it won't open unless somebody opens it. And that is in the record. So there's...
Was it the case that the employer, or maybe you, somebody started with an expert whose disclosure was that the door was open and the employee opened it?
We believe that that was going to be the testimony, Your Honor. And
Based on?
Based on the examination of the police materials, some other things by our expert. We had actually done a disclosure of the proximity of the man's hand to the door, and just the way that the evidence came in, we had our expert sit in there through 4 days of trial. When it came time for him to testify, he testified, and he believed that based upon Robitaille's testimony, based upon Richmond's testimony, and based upon Clement's testimony, that the door didn't open. And so there's only one way for the man to go out, and that was through the window.
So the note, if I was the judge, the note I would make would be this: adequate evidence that the door was closed and latched with 2 tightened and operative screws. Is that fair to say?
That is extremely fair to say. And I would also, if I have time, address that Anderson case.
You have 51 seconds.
Okay, I will use it.
49 now.
Keep going. Just stay.
The Anderson case was simply a claim for benefits, and I think that
It's the language in Thayer that's
Thayer.
it's the reference to 28 and the
Right.
footnote in Thayer
Right.
that gets you into 7A.
And my thought on that, the insurer asserts that there was really no reason to resolve the case for that footnote to be there. It's simply dicta. And the DIA in those 2 cases have taken it and run with it in a way that they weren't made to take and run with it. And the reason why I say that is because, notwithstanding that footnote in Thayer, there's a very exhaustive analysis of what the facts were shown by the plaintiff, by the employee, which entitled the
Of course,
employee to
yeah,
compensation.
I mean, Judge Fischel is a pretty good judge. I mean, she went along with Thayer, though, right?
I am
And
not
Pettit.
sure if she was one of the ones that did write Pettit. Thank you, Your Honor.
Thank you, Mr. Dana.